My ladies, my lord, I'm going to deal with the remaining three grounds of appeal,
Yes.
and I'm going to deal with them in the same order as I did below, which is starting with prior representations, public sector equality duty, then de facto statelessness. So starting with ground 4 of our appeal, which is also ground 4 of our appeal below, which is prior representations. SIAC dealt with this ground, or procedural fairness ground, paragraphs 307 to 352.
Yes.
And I'm sure the court will be familiar with what SIAC said about it. It may help me just to set out the building blocks of the decision, as we'll come back to some of them. SIAC referred extensively in its decision to the Bank Mellat case, and at paragraph 29, Lord Sumption described the duty, he said, to give advance notice and an opportunity to be heard to a person against whom a draconian statutory power is to be exercised, as one of the oldest principles of what would now be called public law. And Lord Sumption and Lord Neuberger, paragraph 179, held the obligation to allow prior representations will only be displaced in two situations. One is where the statutory provision concerned expressly or impliedly provides otherwise. And SIAC held that the duty to permit prior representations, or in Lord Neuberger's word, the rule that where a adverse statutory power is exercised, a person has an opportunity for prior representations, held that that had not been expressly or impliedly displaced by the British Nationality Act 1981. That's paragraphs 307 to 340. Second set of circumstances in which the duty does not arise, or the duty does not need to be met, perhaps more accurately, is where it's impossible, impractical, or pointless to allow prior representations. That's Lord Neuberger, Bank Mellat 179. And as Lord Neuberger made clear, any arguments advanced in support of impossibility, impracticality, or pointlessness would be very closely examined, as a court will be slow to hold there is no obligation to give the opportunity when such an obligation is not dispensed with in the relevant statute. And SIAC went on to consider whether it was impossible or impractical in the circumstances of this case. The Secretary of State had argued that there were national security reasons why Ms Begum could not...
Just pausing, it's my fault, my note. Did you say that it was decided that the BNA had not expressly or impliedly displaced?
Correct, mate. 307 to 340 of the SIAC.
307 to 340. Oh yes, sorry, that was SIAC's finding.
SIAC's, yes.
Yes, yes.
SIAC's finding below. Then held, considered impossible, impractical, or pointless. In terms of impractical or impossible, the Secretary of State had argued there were national security reasons why Ms Begum could not be given prior notice of the decision and an opportunity to have representations made on her behalf. And it may help just to turn up what SIAC said about that evidence, because we will come back to it, and it's particularly relevant to an aspect of the simplex argument I'll come back to. 152 of the SIAC decision, core bundle 125. If the court just glances down now, Miss Locke was asking a searching question about the timing and speed of the decision making in this case. He said the Secretary of State was concerned about national security and was desirous of taking decisions to protect national security. Mr Larkin could not satisfactorily explain the 6 months delay in the similar case of C3, C4 and D4. And just turning back on that, or the page before 145, what SIAC had said about Mr Larkin's evidence, he's the Home Office witness, is that save in relation to the timing of the decision and one aspect of his closed evidence, Mr Larkin was a satisfactory witness, so it was concerned about his evidence on the timing, and then it set out its conclusion on that at 342, page 160. So if the court has that, it rejects the national security argument. It says, last line, political rather than national security factors drove the outcome, and that's referring to the speed of the decision rather obviously than the merits of it. So it rejects the Secretary of State's impractical, impossible argument. It then dealt at 343 with, in Lord Neuberger's third rubric, pointlessness. And it there said it would have been pointless, or it refers to the decision in D9 of the Commission, that it would have been pointless to allow representations to be made on national security. And I'll come back to that because we say that is wrong. It seems to have been treated by SIAC as some general principle. You see that when you refer back to what it said at 339. So I'll come back to that conclusion. But it said a lot she could have said on other matters. End of the page. An individual may have rather a lot to say about proportionality and overall justice of a decision removing a fundamental right. What SIAC then concluded ultimately is that SIAC thus concluded there had been an error of law, that's paragraph 409, in failing to permit representations, hadn't been removed by statute, not impracticable, pointless, etc. But it held outcome would have been the same. That's 344 to 351. Therefore, simplex and/or immaterial error of law, it's the same test, same inevitability test. We appeal on the simplex conclusion, and in short, our case is this: we say SIAC made two key errors, and I'll take you in more detail to the principles we say apply and to the errors where we say SIAC made these errors, because the nub of the decision, the simplex decision, was 349. I say you put national security to one side, which I'll come back to, and then you have the nub of the decision, 349. And the only thing that SIAC considered that could have been said on Ms. Begum's behalf was she was a child at the time of departure, might have been a victim of radicalisation and so forth, and this was not a decision to be taken lightly, and could not travel to Bangladesh. And it said, well, the Secretary of State was of course aware of those matters, therefore inevitable decision would have been the same. But as I'll come on to in a moment, there's far more that could have been said on Ms. Begum's behalf, both about national security, as I'll come on to, and also public interest telling against deprivation. And the error, we say, is that before allowing a simplex defence, a court needs to be satisfied there is nothing a person could have said that could have led to a different outcome. The court needs to consider all potential representations that could have been made, not one or two. And the simplex defence should only be allowed if none of the things a person could have said could have made a difference, may have made a difference. And that's partly why it's such a high threshold. And here it's not difficult to see the range of representations that could have been made on Ms. Begum's behalf. They were, in essence and in a shortened form, the argument she put before SIAC. I'll come back to those. And what SIAC didn't do is consider some of the key and obvious points. Indeed, there were the points that were put to SIAC, which I'll come to, that could have been put to the decision maker, and which were clearly not issues of which the Secretary of State was aware. We'll see that. That's confirmed in cross-examination.
In a very long judgment, one needs to be a little bit careful about perhaps overanalyzing paragraphs. With these submissions on the simplex test, the submissions that you make now, were they advanced before SIAC?
I mean, part of the difficulty, my lady, is that both parties dealt with simplex very briefly,
Right.
and only in writing. I mean, ultimately, it's the Secretary of State who, once you get to that stage, has to satisfy the simplex test.
Yes.
So, and I have to say, I think, in fairness to SIAC, I think, or maybe speak for myself, I don't think either. Well, we necessarily expected this to be what the case would turn. I say Sir James made no oral submissions on simplex at all, and nor did I. I say it would be his defence.
And so I'm not being Delphic. It's just the sort of first sentence, you know, overall does not consider the representations. What I'm trying to suggest and give you an opportunity to comment on is whether or not it's right to restrict the SIAC's consideration to the specific matters that follow in this paragraph.
Well, I mean, it didn't consider any other, doesn't refer to any others.
Doesn't refer to any others.
And what I will say is that some of those other obvious ones that could have been made are ones that were matters that had not previously considered by the Secretary of State. And if one applies the simplex test correctly, we say, SIAC could not have concluded the decision would inevitably have been set.
And I'm sure you're going to do this, but if you could give, at least for my benefit, the references in the written submissions to what was put on the simplex test, that would be very helpful.
Yes,
Thank you.
I'll come to that.
Thank you.
The second error that we say was made, and it's to some extent a linked one, is that we say SIAC didn't approach the simplex defence correctly in this context. In particular, it didn't consider how the limits to its institutional and constitutional competence set out in cases like Riemann, Begum in the Supreme Court apply when one gets to the simplex stage of the analysis. And that's an issue of principle of some importance, which hasn't, I think, been considered by the courts before. As I know this court will be aware, there are a series of different limitations that have been noted, Riemann, Begum, as to the competence that SIAC has to decide whether assessments of national security are irrational, limits the competence it has to decide whether the balance that's been struck between different interests are irrational. But it's our case, as I'll come on to, that all of those limitations continue to apply at the simplex stage of the analysis. But now they apply in exactly the opposite direction, because at the simplex stage, it's the Secretary of State who has to say no rational decision maker who heard XYZ representation could have decided anything other than I'm still going to deprive. So we say all of the questions about institutional competence, matters that are non-justiciable or are ones that it's virtually impossible for SIAC to say this is what a rational decision maker would do, they all still apply, but this time I say they're applying in the opposite direction. So I'll seek to make those submissions good, but that's what we say are the two key errors in the simplex analysis. The Secretary of State also has a...
What test do you say SIAC applied?
Well, they didn't consider this point at all, what are the limits of our institutional competence. The closest they come to explaining setting out a test is at 345.
The test they apply seems to be representations of the nature we're predicating would it have made any practical difference?
Yes, that's the where they come down to it. That seems to be the test they're applying. In fairness to SIAC, I think they did understand that to be an inevitable test,
yes.
But they don't then go on to explain what that means, which I will make submissions on. I say, in fairness to SIAC, it didn't have much help on this, I think, from either party. But I will show you what we said in the skeletons about it.
Thank you.
That's our appeal. The Secretary of State also, or cross appeals, or strictly puts in a respondent's notice. What he argues is that even if there were no national security reasons not to permit representations, even if representations may have made a difference, there is no obligation to permit them because that has been removed by necessary implication by the BNA in 1981. I was intending to deal with that in reply, if I may, rather now, not least because we had thought this point had been conceded below. It's in the supplementary bundle, page 61 to 62. I won't take that because I'm not holding the Secretary of State to this concession, but I would like to see how Sir James makes this argument, because below we had understood that point was not being run, that it was accepted if there wasn't a national security. It was said there will very often be, and was in this case, a national security reason not to allow. But as we understood it, it was conceded that if there wasn't, if that did not arise, the statute had not removed, there would remain a duty to seek representation. So turning then to our submissions on simplex, I was going to make three submissions of principle first, which apply, but in fact they apply generally to how one approaches simplex and how one approaches the Secretary of State's, or will approach the Secretary of State's cross appeal. And these are general points about fair representation, which I hope I can deal with relatively quickly. The first point is fairness is context specific, and a key element of that context will be the nature of the decision and the importance of it for the person affected. And we do say this is, in terms of executive power, this is either the very top end or very near the top end of what the executive can do to a person. It is devastating for a person to find that they have lost their British citizenship. We only have to see what the impact is likely to be on Ms. Begum. Fair chance she will never see her family again, having been, we say, trafficked out of the jurisdiction. There's also, we say, no other state that is going to recognise her. So the impact for her really is devastating. And that goes to, one, what fairness requires, but also how carefully one does the simplex analysis. Second point is the value of a fair decision-making process. And we say this, the role of a fair process is partly to ensure a decision is properly informed and the decision maker has all relevant information before him or her. And as the courts have noted, very often people will have something to say, and that's, again, partly why the simplex hurdle is so high. But there are also other values of procedural fairness. And if I can take the court, again, briefly to the Osborne and the Parole Board, which you have in Volume 2, tab 29, page 791 of the authorities bundle.
That reference again?
Tab 29, 791.
Is it 2?
Volume 2, yes.
29.
So this case is about recall of prisoners to prison, and it's a circumstance where in fact they had significantly greater procedural protection. They were allowed to make representations to the parole board, but generally speaking the parole board would not allow an oral hearing, and that was held by the Supreme Court to be unlawful. And Lord Reid, with whom the others agree, paragraph 66, page 825 of the bundle reference, sets out paragraph 66 to 71. The values of a fair process. And so 66 to 67, it's the first value, which is ensure the decision maker has all relevant information. That's first line of 67, one of the virtues of procedural fair decision making, liable to make better decisions. He then identifies two more. 68 in the middle, next to the letter E, is that justice is intuitively understood to require a procedure which pays due respect to persons whose rights are significantly affected by decisions taken in the exercise of administrative or judicial functions. And then he quotes from Jeremy Waldron's article on how law protects dignity, with this quite striking. Now, applying a norm to a human individual is not like deciding what to do about a rabid animal or a dilapidated house. It's about paying attention to their point of view. It's about treating people with dignity, allowing them, hearing what they have to say. And the second, paragraph 71, the second value, he says, is a value of the rule of law that's engaged. And we say that's going to be relevant to, again, both the respondent's notice point, but also, again, to simplex. And we'll see this picked up in some of the simplex authorities, that we're not just concerned with getting a decision right in the sense of having all relevant information. There are other values. And again, we say that applies a fortiori. If you're doing something as devastating, someone's taking away their citizenship, giving them an opportunity to say something or to have something said on behalf is partly about recognising that. Third point about principles of fairness is the courts have repeatedly stressed the importance of allowing prior representations and representations to the decision maker. And there are a number of reasons for that. Two are set out in Bank Mellat. Again, I'll just give you the references. It's Lord Neuberger 187 to 189 and Lord Sumption 37. And they both make similar points about the value of being able to make representations before a decision is finalised, at the stage when it is still being considered. And in our skeleton, again, I won't take you to it, we quote from SP, our skeleton paragraph 14, we quote from SP, which is at tab 73, one of the new authorities, 57 to 58, which again makes the point the court will be very familiar with, that inevitably it's hard to persuade someone to change their mind once they've made a decision. It's at the formative stage that representations are critical. And the other point made by Bank Mellat, of course, that is being able to challenge things afterwards through an appeals process can take months, if not years. But the third reason that representations to the decision maker are so important is something which, again, I don't know has been considered before in the authorities, but is distinctive to this sort of case, which comes back to the Riemann and Begum in the Supreme Court point, is that SIAC's ability to interfere with a decision on the merits of deprivation is extremely limited. There is some ability, CU3, to make limited findings of fact, but in terms of the Secretary of State's assessment of national security, how the Secretary of State assesses it, what level of risk the Secretary of State accords a person, how the Secretary of State balances that with other factors. We'll see from SIAC's judgment here, it is, SIAC's words, impossible or almost impossible to conclude that what the Secretary of State has done is an irrational decision. And what that means, it is absolutely critical for a person, if there's no national security reason for denying it, to be able to make representations to the decision maker, because that's going to be, in reality, the only chance they have to say, look, to make any representations on their merits. Because once you get to SIAC, we'll see what SIAC says about its ability to disagree with the Secretary of State's decision. So it's the decision maker at that stage for a decision of this importance. So those are my three general observations. Can I then make some submissions about simplex and what we say is the correct approach to the simplex defence? And I have 6 principles, maybe call them principles a bit over the top, 6 points about simplex. First is that establishing that no remedy should flow from an unlawful act and it should simply be allowed to subsist rather than being remitted for reconsideration is very unusual. That's the wording we'll see in various authorities, something of great rarity. Usual order is, if an unlawful decision is made, it goes back to the decision maker. And we do say that ought to again be a fortiori when you're talking about deprivation of something as important and fundamental as deprivation of citizenship. Second, there are 2 reasons why it's very unusual for a simplex defence to succeed, and the usual outcome is you go back to the decision maker. First, it will often be impossible to know that what a decision maker would have done if they heard representations. It's the point I made earlier. The court has to go through every plausible thing a person could have said and say, look, none of these would have made a difference. The second reason for the high threshold is because simplex isn't only concerned with, or sorry, put it differently, procedural fairness is not only concerned with outcome, and we'll see this in the simplex cases, it's also concerned with the issues set out in Osborne about the dignity of allowing people to participate and about the rule of law. Again, that explains why it is so unusual. Again, we'll see that in the simplex cases. Third, we say the correct test in applying simplex is this. A decision will inevitably, which is the wording used, be the same if a hypothetical, open-minded and rational decision maker will be bound to make the same decision if they had acted lawfully. So, and it has to be a hypothetical and open-minded rational decision maker rather than this decision maker. Because by definition, we know this decision maker has acted unlawfully. So it'll be a bizarre exercise to say, imagine someone like that. It has to be a hypothetical, rational, open-minded, which SIAC did accept at 345 of its decision. And in the context, sort of simplex applies to all sorts of legal errors, but in the context when one's talking about prior representations, the court has to be satisfied that it's inevitable that an open-minded and rational decision maker minded to deprive, because I accept that's the stage we got to, someone minded to deprive who then heard representations, is it inevitable that they would have reached the same decision, still decided to deprive? And what that means, to put it the other way around, it has to be irrational. It's only if it will be irrational for someone who heard representations and minded to deprive to say, well, okay, I've changed my mind, that it will be inevitable the decision would be the same. And I say there will be cases like that, albeit extremely rare, if, for example, the only thing a person could say is something that has already been taken into account, then you can see a rational decision maker minded to deprive, having heard something that was already before them, isn't going to change their mind. That isn't rational. But we say in our case, and in many, many cases, it will be possible for a rational decision maker, not irrational, for them to say, you know what, actually I've heard this, I'd like more time, I'd like to investigate more, whatever it is. Fourth, and this links to that, and this was the error identified earlier, in deciding whether no rational Secretary of State could have decided to deprive, SIAC has to take into account its institutional role and the limits of its institutional competence. We say they all apply. They play just as much when SIAC is considering, at the substantive appeal stage, if you like, is this an irrational decision? At the same, it also applies when it is considering a simplex defence, because it is again saying, can I be satisfied no rational decision maker would have changed their mind? Well, and again, it'll probably make more sense when I come to see how this works in practice in relation to the representations we say Ms. Begum could have made. And all of those constitutional, institutional limitations still apply to what SIAC can and can't do, what is able and unable to decide. Fifth, in considering the simplex defence, it's important to be clear exactly what the counterfactual is one is considering. One does need to set out, it's maybe time for the point Lady Chief Justice put to me, it does need to be clear what all of the different possible things that could have been said are, because otherwise, for two reasons. One, because you can't be satisfied that none of them could have led to a different decision unless you're clear on what they are and you've considered all of them. And two, depending on their nature, then questions of SIAC's competence will arise, because it will depend on what the particular if it's a purely factual representation. It may be SIAC would be able to make determinations about that. If it's not, we say that's when questions of institutional competence arise. And the sixth point we make is that the burden in simplex cases on the Secretary of State, that it's he that has to show that the decision is inevitably the same. And so he has to produce some evidence or some basis from which the court is able to decide that the outcome would inevitably have been the same. So that's my 6 principles. Can I, just to make those good, show you briefly the key authorities on which we rely? The first is the one that's often cited in the simplex context. This is not simplex itself, in fact, which is rarely goes to. It's Cotton, which you have at volume 1, tab 10, page 70. And this is a case about an overweight police constable who was dismissed because it was felt or was decided that he was not physically able to perform his duties. And in fact, the decision had been taken fairly. You can see why in Lord Justice Bingham, as he then was, his judgment at 61 to 62. The key part, or what this authority is often cited for, is the principles Lord Bingham set out in paragraph 60. Page 79 of the electronic bundle. And he sets out 6 principles. And he starts, I'd expect these cases, ones in which you deny a remedy, or denying the subject of a decision an adequate opportunity to put its case is not in all the circumstances unfair. I expect these cases to be of great rarity, number of reasons. The first 2 are effectively it's very hard to know whether you make no difference. That's John and Rees. There's then paragraph 4. This is a version of the institutional competence argument I was making, is that the court needs to make sure it is not turning into the decision maker. And we say a fortiori here, where there are limits, very clear limits to its institutional competence to make decisions. And the last 2 are variations of the Osborne, if I can put it that way, Osborne concerns about effectively that dignity, appearances matter, about the rule of law. These are rights. Therefore, one shouldn't easily say, well, it didn't matter that a right was breached. These similar points have been picked up in lots of cases. I won't take you through them. They're set out in our skeleton. We refer our skeleton to Smith at 54.2, 54.5. Make similar points. Balajigari, refers to our skeleton 54.3, makes clear, well established, the court should observe great caution in refusing relief. Paragraph 135. But one case I will, if I may, take you to briefly, it's another set of principles. It's the Criminal Injuries Compensation Authority case in the Court of Appeal, which you have at tab 2, volume 2, tab 38, page 1099. This is a Court of Appeal decision. It was appealed by the Criminal Injuries Compensation Authority against the decision of the upper tribunal. What the upper tribunal held was that the first tier tribunal had made an error of law, but it would make no difference to the outcome of the case. And the Court of Appeal held that the upper tribunal had taken the wrong approach. It sets out principles at paragraph 7, 1102. And we again say these are, it's a different context, but we again say these are generally applicable. Basic principles related to judicial review generally mirror this statutory framework. That's the Tribunal of the 2007 Act. Material error of law established, decision can't stand. Most cases, not be a proper exercise to refuse relief. Again, this is the don't substitute. It's not for the court to substitute its views for the decision maker. And then it sets out this, which of course is from a different context, which say is effectively the same test. Substitute its view only if, once allowance had been made for the error, only one decision was open to the decision maker. That's another way of putting the inevitability test, is that no one rational could have done anything other than, in our case, uphold the decision to deprive. One further authority on simplex is Harvey, referred to in our skeleton at 66. It's same volume, tab 45, page 1404.
Sorry, your skeleton what paragraph?
We refer to it, should be 66, I think, is my. No, the case is at volume 2, tab 45. It's Harvey District Council. And this case is run, this case, in terms of what evidence is required from the defendant in order to establish the simplex defence. What had happened here was a planning case. Planning permission was granted on the basis the proposed development was in conformity with a local plan. The council argued that was correct, but even if it wasn't, the same decision would have been made. And the Court of Appeal held the development wasn't in conformity with the plan, and they rejected the argument that the same decision would be made. I should say this is a case decided under 31(2)(a). This is a judicial review case, so it's a lower threshold. It's highly likely, not inevitable. And it's Lord Justice Sales, with whom Lord Justice McFarlane agrees, Lord Justice Sales, who then was, page 1415, paragraph 47. And if the court sees, maybe just glance down paragraph 47. The caution that's expressed there by Lord Justice Sales about post facto evidence is a point he made also in the PCSU case, which you have in the bundle. He says, we exercise caution, but nonetheless, even with that, it's telling there isn't any evidence on what they would have done. And without some evidential basis, one can't uphold even the highly likely test.
But there was no submission either, absence of submissions and evidence.
And we'll come to that when we look at, again, what the representations could have been in this case.
I mean, there's an internal circularity in all of this, isn't there? In the sense that if you say it's got to be the hypothetical and not the actual, what evidential value does evidence from the actual decision maker have? I think that's
where
you've got to jump.
Yes, I think that's absolutely right. I think was the point in part that was being made here. But one needs an evidential basis. Perhaps I can put it this way: in order to uphold the simplex defence. But again, when we come to the specifics in this case, I can show you how we say that applies. Turning next to the legal framework on institutional competence. Of course, this is ordinarily the early part of the appeal, something the Secretary of State heavily relies upon. But of course, we say it must apply equally. SIAC's institutional competence doesn't change. And if we have a look at how SIAC dealt with it, it's probably the easiest way because it summarises, SIAC in our case, summarised the key principles. back in the core bundle, page 103, paragraph 37 of SIAC's decision. It sets out the role, it's under the heading, the role of SIAC, and 37, 38's first two propositions, first two headings, it's a Wednesbury test to the extent matters are justiciable. Then second, some matters are simply not justiciable. Others entail an evaluative judgment which is incapable of objective assessment, e.g. nature, level of risk, etc. Commission is able to investigate, but must apply familiar public law principles. And it's referring, the language there comes from, and it might be helpful just to turn this up, from Begum in the Supreme Court, which you have volume 2, tab 49. And it's paragraph 70. You'll see the language that SIAC is picking up. Lord reads.
That's the wrong reference, not authorities 2, it must be authorities 3, isn't it?
I think it's 2.
I've got depends on which edition.
Oh no, sorry, it's page 1. Oh dear.
Tab 49.
Tab 49, sorry. Tab 49, page 1531. This is how one approaches rationality, says Lord Reed. You'll see the language used by SIAC. It's picking up on what Lord Reed said in deciding if the Secretary of State is acting in a way no reasonable Secretary of State would have acted. Regard for the nature of discretionary power, and that's the some non-justiciable, some evaluative judgments, end of the paragraph, need to be accorded respect by reason of institutional capacity and democratic accountability. And it's not only, you'll see how SIAC holds in relation to national security assessments that it is said SIAC needs to defer, assuming the Secretary of State has taken into account all relevant factors. How he weighs them, how he assesses them, is again a matter for the Secretary of State, and SIAC makes that point on the page before, if we're back in SIAC's judgment, page 102. This was what, paragraph 31, 32, this is what SIAC said about the Ali case, the Lord Kerr judgment, which my own friend took me to this morning, which is that this is the public interest is multifaceted, including families being kept together, welfare of children, encouraging, respecting rehabilitation. And what SIAC said is, but it's extremely broad. And ultimately, towards the end of the paragraph, how the Secretary of State weighs any of those factors is a matter for him. And one of the consequences of all of these limitations is, SIAC says, paragraph 59 and 60, page 108, that even when SIAC is deciding for itself where a balance lies in a convention case, middle of paragraph 60, if the public interest germane to Article 8.2 of the ECHR, to take the most obvious example, is incapable of objective assessment, i.e. national security, it's almost impossible for the Commission to displace the primary judgment of the decision maker as to where the relevant balance falls. So if the Secretary of State has balanced relevant factors, it will be almost impossible to say you've got it wrong. because of SIAC's, the limits of SIAC's institutional competence. Finally, on the authorities, I want to deal with what's said in U3 in this context. It was in dealing with the simplex defence, SIAC, at paragraph 350, referred to an observation of the Commission in U3, paragraph 33, and the Secretary of State relies on that. He relied on it before SIAC and relies on it again. So if you have U3 is in volume 3, tab 55, the authorities fund. And the relevant paragraph is 33. This is the paragraph that SIAC quotes and the Secretary of State relies on. And you'll see what SIAC says, paragraph 33. Another concept of SIAC's specialist constitution and unique procedures, there may be cases where a flaw that appears at first light to be material can be shown not to be. And then further down, SIAC's more powerful microscope, and I'll come back to what that means in a moment, may enable it to see more clearly not only the potentially significant flaws, but also their evidential context. It means it may be better placed than the judge in a JR to say wasn't material. Now, it's important to see the careful use of language. This wasn't suggesting some different rule in SIAC. It was always may. It may be that SIAC's more powerful microscope may enable it to see more clearly that an error wasn't material. And that now needs to be read in conjunction with what the Court of Appeal said in U3, which you have at tab 58, so a few tabs further along. So this was the appeal in the Court of Appeal. The Court of Appeal there explained what the differences between judicial review and SIAC's jurisdiction were. And the key practical difference is that SIAC is able to hear cross-examination, to consider post-decision material. And that enables it to make findings of fact, at least in a limited sense. If you go to paragraph 174, page 1855, it sets out the different SIAC can hear cross-examination, etc., here's live evidence. In other words, and then what that means it can do is if it considers it can, and that they're appropriate, SIAC may make findings of fact, which may be relevant to the assessment of national security. And then this is important, as long as it does not use those findings as a platform for substituting its view of the risk of national security for that of the Secretary of State. The findings of fact are the material on which SIAC must apply the tests set out in Riemann and Begum when it considers any challenge. And then it gives one example. If, for example, SIAC concludes that a person simply wasn't in Syria when they were said to be, or it's not the right person, SIAC can make those findings of fact as long as it respects the limits expressed in Riemann and Begum when it considers a challenge. Now, what that means in terms of the simplex argument is this, and this is the more powerful microscope point, is that there may be circumstances where SIAC's ability to make findings of fact will allow it to decide that an error is not material. So, for example, if a person says, I wanted the opportunity to make representations because I would have explained that I was never in Syria, or the Secretary of State has just got the wrong person, the points that were picked up on the Court of Appeal. Now, as SIAC held, as the Court of Appeal held, SIAC will be able to hear evidence, hear cross-examination, and it may conclude the person was indeed never in Syria, in which case it'll allow the appeal. But it also cuts both ways, because if SIAC concludes the person was in Syria, it will be able to say that is not a material error, because you would have wanted to come along and say I wasn't in Syria, but in fact you were, so therefore not allowing to make representations would not have made a difference. But all of it depends on what the particular issue is SIAC would be considering at a simplex stage. Our case is not one where the representations would have been, you've got the wrong person, I was never in Syria. They're not factual, discrete factual matters of that kind. We'll see in a moment what they would have been. And they would have been matters that SIAC simply can't, and we'll see didn't feel able to make findings upon. So those are the authorities where I got the 6 propositions that I made earlier from. Can I then turn to how the issue was presented, argued before SIAC, and then what SIAC did? The initial submissions made on simplex you have in the Scott schedule, which is at page 65 of the supplementary bundle. Supplementary bundle, page 65. It should be the Scott schedule. So this is where the list of issues, because obviously there isn't, the Secretary of State doesn't put in pleadings in SIAC cases. So he sets out his case in the Scott schedule, page 65, and you'll see the way this was put at that stage. You see number 3. Grounds 1.7, all advanced arguments based solely on alleged public law errors. Secretary of State's position is that those alleged errors are not made out for the reasons summarised below. However, her position is that even if they were made out, the appeal could only succeed if they were such as to render the deprivation decision irrational. None of them, either individual or cumulative, would reach that threshold. Now our response, you'll see over the page, is that's entirely the wrong way round. That's simplex on its head. That's saying that once we've shown the error occurred, we then have to show the decision was irrational. So that clearly is not, we say, the correct legal approach. The Secretary of State's position is then set out in his schedule. So I'm calling him. I know he's changed, but I think we've decided rather rarely in this case it is a male Secretary of State made the decision. But he, in his skeleton argument 269, supplementary, yes, sorry, this is the skeleton below. And as I say, neither party, you see, gave SIAC an enormous amount of assistance on this. It's the 4 paragraphs at the end. The Secretary of State deals with it. You see, a large part of it is the quote from U3 that I took you to. But what the Secretary of State invited SIAC to do is to say, look, given the national security assessment, it's inevitable the decision would have been the same. 233. And then 234. And that's, again, we say obviously not the correct approach, because that is inviting SIAC to make the decision for itself, which is precisely what it is not permitted to do. If one take an example, de facto stateless, this was one of the issues we said needed to be considered. As we'll see, SIAC held ultimately it was considered. It needs to be, but was. But suppose it wasn't considered, it's plainly not proper for SIAC to say, well, we'll balance national security against de facto statelessness and decide it for ourselves. That is precisely to substitute its decision for the decision maker, which is what the Secretary of State was inviting SIAC to do. To do, if something wasn't taken into account, well, you can do the national security balance yourself and reach a conclusion. We say clearly not. And then our position on simplex was at earlier on 201. We set out.
I was just reminding myself, Mr. Squires, it's only relevant, I think, to the respondent's notice point, but obviously you've read the way it was argued in U3, both at first instance and in the Court of Appeal, so far as the procedural point was concerned. This point, so paragraph 41, for example, Mr. Justice Chamberlain's decision said the law allows, under section 40, allows the Secretary of State to deprive U3 of her British citizenship without giving her the opportunity to show before the decision was taken. that she doesn't pose. So
Oh, and we've never disputed that. It allows it if there's a national security reason, which there normally is. I have to say, in most of these cases, the reason it hasn't arisen before is there's normally a national security reason. I think U3 was somewhere in Syria at the time she was deprived. I'd have to check. I'm fairly sure she was. Clearly, there'll be a national security reason about finding her and warning her. And that's normally how it works. The reason this case was different is Ms. Begum was in detention. So it is correct that ordinarily if people are out of the country, I think if they're in the country, again, there's no particular reason why they shouldn't be allowed to make representations. I don't think it was suggested, and this is certainly not how SIAC read U3, was saying there is some rule that you are never permitted representation. It is true that in many cases you aren't. That's the way these decisions work, but it depends. Depends if there's a national security reason for not permitting.
so your position is on the facts of this case. Section 40 meant that the Secretary of State nevertheless had to give your client the opportunity to make submissions.
Well, our case again, I'll make this once we see how it's
Yes.
put, but it's the normal rule is Neuberger assumption. You read in an obligation to act fairly, unless it's displaced by statute, and we say it simply is not displaced by statute. Or
Right. Anyway, as you say, you'll
yeah,
deal with
essentially we say it's displaced if there's a national security reason to displace it, and SIAC held here on the facts. There was not a national security reason to displace. I say this is discussed in some detail in SIAC's judgment. We set out 244 to 249 simplex, and at one point I will take to you, because what I'm going to come to next is we set out some of the things that the Secretary of State would have needed to consider and why you can't conclude. That's at the top of page 203.
213. So
203.
203.
Yes.
Your skeleton argument.
Yes, we say by way of example, this is
Okay.
why we say you can't conclude inevitable. Things like investigating, determining trafficking status and the state failures related to her trafficking, properly taking these matters into account, then assessing the risk, deprivation will be conducive to the public good, can't be said inevitable. And let me then turn, if I may,
On page
203. So this is why we say
Amendment.
Right, my fault. So, thank you very much. 248.
248. We'll give some examples.
Don't worry, everybody else is ahead of me.
But it's sort of this bit crosses over a bit with the submissions we've already heard on ground one, because we're back into the trafficking point.
We are, and I'll come back.
Other bit, there are other angles to take on it as well.
But I'll come back to it. But he now operates, as we'll see in a moment, in exactly the opposite direction. It's probably nearer to, we'll see in a moment, to a ground two, or the issue about are these mandatory relevant considerations. Can I set out what we say? Because I will come back to this point, how this relates to, but I'll come back to what we say, what would be the kinds of representations that would have been made, which we've, say, summarised very briefly there. But in effect, it is what was said to SIAC. It would have been said, overwhelming evidence, this is a child who was a victim of trafficking, trafficked clearly to sexual exploitation, to have sex with an adult male, age 15. And it would then have been said, there is at the very least a credible suspicion of serious state failure. Again, these are all representations. We could go further than that and say, this is actually a clear case of state failure, and I won't take the court through it. But even if one looks at the agreed chronology, you can see the obvious failures here. With a friend being trafficked, another girl being trafficked the next day, the obvious risk, etc., etc. It could then have been submitted that these failures were unlawful. You have breached your obligations to this girl by failing to protect her, failing to investigate. And it would then have been said, or could then have been said, this is relevant in two different ways. It could have been said, this level of state failure in relation to a girl who we owed obligations to means it just is not in the public interest to deprive her of her citizenship. We saw Lord Kerr in Ali said, conducive to the public good is very wide. It can include welfare of children being given primacy, encouraging and respecting rehabilitation of offenders. It could also potentially include, come back to this in a moment, the state complying with its legal obligations to victims of trafficking. And it could also be, if it's put in lay terms, you could make the submission, look, we failed this girl, and it is just not appropriate. It's not conducive in the public good to deprive her of her citizenship. And the second...
Well, wait a minute. That's blurring in terms of section 40. Whether the test is surely whether her presence in the country.
Sorry, my lord.
Isn't the test whether the presence in the country is?
No, I think it is just conducive to the pub, and that's why we relied on the Lord Kerr in Ali, where he said it is incredible. He said there, paragraph 30, quoted in SIAC, paragraph 31, and SIAC accepted very, very wide what can be put into the public interest when you're looking at conducive to the public good. He said things like encouraging and respecting the rehabilitation of offenders, very, very broad policy objectives, and SIAC accepted that. But, and this is the critical part to my lady's question, how it relates to the grounds, it said, but how you weigh them is a matter for the Secretary of State, how he weighs all of these different things. But we do say there is no reason at all why we failed this girl, we failed to protect her, we breached our obligations to her, could not be factors the Secretary of State would be asked to take into account. And I'll come back, as I say, how this relates to the grounds 1 and 2 of the appeal in a moment. And the second point that set submissions could be made was how this relates to national security, the assessment of national security. Before turning to those two headlines, can I make 3 initial points? The first is this not a case where SIAC's more powerful microscope to make factual determinations has any relevance. Because this is not a case where SIAC said, well, we heard the evidence and she clearly wasn't trafficked, or there was clearly no state failure. You saw quite the opposite. That isn't the conclusion SIAC reached. It's not one where it said, well, we heard evidence and wouldn't have mattered if you said this stuff. Second point is in relation to the state failure issue, did we fail this girl as a victim of trafficking? It is absolutely clear that was not something SIAC considered. And, that was clear that that was not something the Secretary of State considered when he took the decision. It's nowhere in any of the documents, and in cross-examination, Mr. Larkin, the Home Office witness, confirmed, it maybe helps to turn it up, it's supplementary bundle page 16. It's the top of page 16. Question from me, is the Secretary of State told anywhere when he took the decision what might be the legal consequence if Ms. Begum was a victim of trafficking? No, and there's all sorts of reasons for that. State failure, page 22, halfway up. Paragraph 16, did he, the Secretary of State, consider whether there was any UK public authority might have failed to protect her? Your question, if your question, did advice go to the Home Secretary, the answer again is no. And it is clear this wasn't a factor the Secretary of State considered at any stage when he took the decision. So it's not something one can say, well, he was aware of that, couldn't have made a difference. Third general point, and this is the relationship between grounds 1 and 2, because the Lady Justice Whipple is of course right. There's a similarity to grounds 1 and 2 in that these are the submissions that could have been made But they operate here in an entirely different way, because if we're right, I mean, if we're right on ground 2, or the common law one, this was a mandatory relevant consideration. SIAC had to consider legal obligations owed to trafficking victims, or ground 1 had to consider it in relation to Article 4. But suppose we're wrong on that. Suppose the Court of Appeal accepts that SIAC was entitled to find on the common law argument it was not irrational for the Secretary of State not to consider those matters. That does not mean it would be unlawful to have considered them. There's 3 different categories of
Can I just pick away that? If you win on ground 2, do you say this ground falls away? If you win on ground 2, you'd have won on rationality. All this stuff would have had to have been taken into account. Doesn't add anything, does it? To say she ought to have been given a
chance to say this stuff, which he
same point. They should have taken it into account. So that sort of marginalises it. But you say that if you lose on ground 2, so there's no mandate in the Secretary of State to take it into account of her own bat,
Yes.
you say still she has an obligation.
No.
She should invite views in advance of the decision.
Well, the obligation is to invite views anyway, if we're right, if SIAC is correct.
These are the sorts of things that could have been
And
said.
could he said, and the only reason you could say, well, as I say, there's 3 different types of relevant consideration. There's ones that are mandatorily relevant. It is irrational not. This is a common law. Irrational not to consider. That's our common law. I suppose you're against us on that.
It's still lawful to consider.
Precisely. So that's
Lawful to consider it. They might have made a difference.
Yeah.
exactly. So that's why you're going to come to next. But it's not. It doesn't fit within the category. There's the main bulk of category is up to the decision maker. There's another category that says mandatory irrelevant. I.e., if a decision maker considered this, that would have been irrational. I don't think no one could seriously suggest these are things it would be irrational for a decision maker to consider. They're in the, if we're wrong on our common law ground, they're in the middle, could have considered. And then the question is it inevitable if those points had been put that the Secretary of State would have reached the same decision? Would no rational Secretary of State have listened to those submissions and said, gosh, I haven't thought about state failure. I haven't thought, again, in vernacular terms, we have failed this girl. I'd like to pause this. I'd like to investigate more. I'd like to think about this further. Is that an irrational decision? And we say it doesn't come close to being an irrational decision. And one of the difficulties is SIAC didn't consider this because it only considered those narrow. It said, well, all she could have said was, I was a child, I was a victim of radicalisation. I say there's far more she could have considered, could have said, and did say.
And the best place to find the more
Is what we said to SIAC. I mean, it's a summary of.
Right, is in paragraph whatever the paragraph was on page 203.
A very short
Let's go
summary of it.
But that's it, right? And is there anywhere else where you set out what could have been submitted?
No, and the submission
that's
is
it, that's
it will be a shortened version of what we said to SIAC. So I can give the references in our skeleton argument below, but it's those sort of submissions,
I see.
state failure,
Good.
etc. And this is where one comes to this is where the institutional competence point comes in, because what we say the Secretary of State has to satisfy SIAC is that had these issues been raised with the Secretary of State, had the Secretary of State been told, we have failed this girl effectively, there is state failure, here it is, here are your obligations, could a rational and open-minded Secretary of State have said, well, I'm going to pause? Is it irrational to conclude I'm just going to carry on? And the answer to that is, A, that would require SIAC, in effect, to make the decision itself, which it, on our ground, our common law ground, it made very clear it was not doing. It said, I can't decide that. It's not irrational for the Secretary of State not to have considered this. That was it. Nowhere is it suggested that SIAC can consider that for itself, but that is what the Secretary of State would be asking SIAC to do. To say, and it's and moreover, it is inevitable. no rational Secretary of State could have done anything different. And so that's why it's such a high hurdle. And that's why we say it's not crossed here. And I said you can flip it the other way round. Imagine the Secretary of State had listened, had thought about this and said, you know what, I do want to pause. I am concerned about our failures in relation to this girl. If you imagined, hypothetically, someone had standing to challenge that and came to court and said, well, look, that's irrational. We know exactly what Sir James would have said. It would be, that's not even a question for SIAC. SIAC simply doesn't have the constitutional competence to say that's an irrational decision. Even if we're wrong, it may not be irrational not to have considered it, but certainly it's not irrational to have considered it, and it certainly wouldn't be irrational to say that's outweighed. As I said, it's not within SIAC's competence, really, say, to make that sort of decision on rationality. How one weighs these are very much matters for the executive. How you weigh these obligations. So that's the first part. And we do say, and this comes back to we also say this is a case in a sense like Harvey. This was one we say, well, there isn't any evidence or submissions before the court. The court simply
Submissions. We've looked at them.
The submission was national security outweigh, but not what Lord Justice Sale says. I just don't know what would have happened.
Yes, in his case, he does say that.
And we say the same. And the reason we say this is the Secretary said at no stage, and I appreciate the point about it is the hypothetical one, you treat it with suspicion, but even that, at no stage has the Secretary of State subsequently said, I have considered state failure in this context. So there's simply no evidence at all.
But there are submissions.
Sorry?
There were submissions.
The submission just said national security would outweigh everything, was but that we say is that's asking SIAC to do the balance for itself.
Yes.
Second set of submissions that could have been made would have been on the question of national security. And what SIAC said about that is it appeared to assume there was some point of principle that submission simply cannot be made. It is always pointless to make submissions on questions of national security. If you have, then back to SIAC's decision,
As we do that, Mr. Squires, you know that you've got the rest of the afternoon to
Yes.
deal with your additional 2 points, so you're managing your time.
I am.
We'll finish at 3:15. We started at 10 to 2. 4:15, I mean, sorry, 4:15. Yes, thank you.
What SIAC said, paragraph 339, page 159, bottom, the paucity of reasons received by the subject of the deprivation decision will render it difficult, if not impossible, for her to contradict the national security case. It seems to be treating this as a general proposition. That's then picked up again at 343. Reference D9, it would have been pointless for the individual to be given prior notice. Nothing that could usually sensibly say on national security. We respectfully agree. And again, 346, we've already held any attempt by Ms. Begum to challenge the national security case at the pre-decision stage would have been fruitless. It seems to have been treated in some sort of legal principle that there is nothing a person can say about the national security case. And it seems to be based on the fact that they don't get, the reasons they get are fairly minimal. Now, first, of course, if you need more reasons in order to make representations, you are entitled to them. That's a well-established principle of fair process. But, in fact, in this case, it wouldn't have been necessary to have any more reasons than the ones that SIAC said Ms. Begum was entitled to, which was, it was assessed that she's travelled to Syria and aligned with ISIL. And in fact, it's obvious that was the national security case. And there was a great deal that could have been said about how you assess national security in that context. And again, it mirrors the points that were made this morning as part of our positive grounds, these are mandatory relevant considerations, how do you assess the travel of a 15-year-old girl, whether it's voluntary or not? How do you assess why she might have stayed with the people who trafficked her? How you assess the press statements that she made? And even if those weren't mandatory relevant considerations, or even if, for example, how an expert in trafficking might have considered these matters, even if those aren't mandatory relevant considerations, they are clearly things that could have been put, could have had, this is what the expert view is on these things, we want you to consider it with that perspective. Now, if we're wrong on ground 2, it's not irrational for the Secretary of State not to do that and to adopt a different approach, but it's also clearly something the Secretary of State could have done. As far as we know, the Secretary of State didn't have any material from experts in trafficking, including from the Home Office, in front of him. Again, if we're wrong on ground 2, it is lawful for him just to have the security services assessment.
SIAC at 346 indicated that the sort of evidence they were considering under pointlessness would have been personal, evidence personal to Shamima Begum, and not the sort of wider evidence that you're talking about now. They said in terms there wouldn't have been time to do that, and that's not really what we're looking at. Were they wrong on that? I mean, are you taking a wider case?
Yes, yeah, yes. I mean, they have to. This is why they have to consider all of the submissions that could have been made.
The whole shebang. So they say in terms there wouldn't have been time to put 346, the powerful evidential case contained with voluminous bundles. So that, you say, is completely wrong on their part. They should have been looking at submissions and effectively your case on appeal, but put in advance of the decision.
What they should be looking at is what could have been put in the time that had been given, and the time that has been that would be given would be, for example, 14 days. If you say, well, you've got 14 days, this is an incredibly important decision, what can you put in? And it was recognised this would be done in reality by Bernbergs, and that is something a firm like Bernbergs are well used to doing. No, they wouldn't have had X number of expert reports, but would they have had the main points? No reason at all why not. Why they wouldn't have had the main points that are made. State failure, the evidence was obvious on state failure. Legal obligations.
So just to be clear, I think you're going to take us to the decision in a minute, but you will be coming on. This is one of the points you're going to pick up, is it that SIAC was wrong to look at it through, to take the view that in practical terms you could only ever be looking at a narrowed case. You say in 14 days you could have effectively put the whole.
Yeah, again, this is why it's an inevitability threshold. But the Secretary of State has to prove that it's inevitable that in whatever time would fairly have been given to Ms. Begum, they could not put any of these points. That's why the burden's on the Secretary of State to say that. And what they'd also have to show, because you recall SIAC's decision, that there wasn't a national security reason for the urgency, and in other cases, decisions had taken months to make. So it would be a very odd decision to say, well, there were things she could have said that would have made a difference, but we're going to decide she wouldn't have been given the time to make them. There'd be no basis for that decision. It's an inevitability threshold. You'd have to have very clear evidence that she'd only been given X number of days for good national security reasons, and in that time she could not have said A, B, and C. There simply isn't evidence of that. You can reach an inevitability threshold.
What do you say about SIAC's paragraph 341? You say that given the postulated opportunity to make representation may be contrary to national security, the Commission's experience is this will usually be so if the individual is outside the country, not least because prior notification runs an unacceptable risk precipitating his or her early return.
Yes.
Do you say that's wrong? That the rule that you must give the subject of the proposed deprivation order the chance to be heard, at least in out, is invariable.
Usually, if someone's out of the country and not in detention, you will not be able to give them prior warning and allowed to make representations. But in this case, that didn't apply. I mean, again, this is going back. This is now the Secretary of State's argument. So I'd say I will develop that if I may. But we do say the general rule is Lord Neuberger, Lord Sumption is allow it unless they're a national security or unless it's impossible. In many cases of when someone's out of the country, they may jump on a plane and return. So, but if the person, for example, is in the country, or as in this case, in detention and going nowhere, there is no reason to deny. And that's the next paragraph. So, so just finishing off on the national security point is that all of these points, or at least certainly some of them, could have been put, and again, that's why it's all so hard for the Secretary of State to establish. If, for example, SIAC had said, it'd been said to Bernberg's, well, you have 14 days, and they said, well, we need another few days to put in an expert report. If that was what was required for fairness, or there was no national security reason not to allow them to do so, of which there was no evidence, or at least the evidence was other decisions took months. And again, I'm not suggesting they would have put in every expert report, but they certainly could have made the key submissions. Trafficking is a question of expertise. Voluntariness is why a 15-year-old girl travelled is a difficult question, etc., etc. It cannot be said that had the Secretary of State considered that and said, you know what, I do want some sort of submissions beyond the security service. I do want some experts in trafficking in the Home Office to help me. That would not have been an irrational decision. In fact, SIAC specifically holds paragraph 285, it may well be the case that experts and those with experience of these matters are well placed to form their own judgments as to whether a 15-year-old girl who may have been radicalised and was not self-motivated acted voluntarily, particularly to travel to sexual exploitation, which she cannot consent to. Whether it is right to describe that as voluntary is something experts will have views on. And SIAC says, 293, many right-minded people strongly take issue with the assessment, but doesn't mean it's irrational. But that also means, had someone put this to the Secretary of State, the Secretary of State might have said, I want some expert views on this other than security services. So that is our simplex.
Thank you.
Simplex argument.
Thank you very
much.
much.
I will deal in reply with the response notice once we see how the argument's made.
PSED.
Sorry.
PSED.
More briefly. Public sector equality duty, we argue there were two factors that the Secretary of State needed to consider but did not. The first was, were his policies and practices such they disproportionately affected Muslims, British Muslims in particular? And we'll see the evidence is striking. It appears the evidence before SIAC was that it's used almost exclusively in relation to British Muslims since 2002 when the power has been used. And what the Secretary of State was required to consider, we say, was if that's so, is that because there is any discrimination within the system? Are there any conscious, unconscious, unlawful practices, or is there some other explanation, some good reason why it's exclusively Muslims? And the second equality issue related to fostering good relations is that we said the decision, such a high-profile decision, entirely predictably had a significant impact, particularly again on British Muslim communities in the UK. But it communicated something powerful about Britishness, who's really British. And many people with no connection, clearly no connection to terrorism and no necessary sympathy for Ms. Begum, felt that this sort of decision communicated something about their place in this country. SIAC dealt with public sector equality duty 382 to 399 of its decision, and we appeal against three aspects of the decision. The first and the main bulk of the decision was that the Secretary of State had a defence under section 192 of the Equality Act. We then appeal against the 1491A decision, that's the disproportionate impact, and then the 1491C decision, which is the impact on Muslim communities. The Secretary of State's also cross-appealed on jurisdiction, but again, if I may, I was intending to deal with that by way of reply. To start with section 192, the court will see it set out at page 167 in SIAC's judgment. Page 384 has section 192, you also have it in the authorities bundle. And it was, a person doesn't contravene this act only by doing, for the purpose of safeguarding national security, anything that is appropriate to do for that purpose. Proportionate to for that purpose is the wording of section 192. And SIAC, the key reasonings at 387, we'll come back to in a moment because we say it's not, the way SIAC put the R on it is not correct, it's not what we were saying. It doesn't turn on the meanings of doing and thing, but then the SIAC's conclusion is, in our judgment, the doing and anything in section 192 can only be sensibly understood on these factors, a reference to the exercise of the function under this separate legislation, that's section 40, rather than to any obligation under the Equality Act itself, including the due regard duty. Thus, section 192 is not looking at the duties and obligations imposed under any provision of the Equality Act in relation to which it is imposing an exemption, but rather to functions arising elsewhere. So essentially what SIAC holds is that you take the duties and obligations under the Equality Act out of the equation, and what you look at is whether the decision under separate legislation, removal of citizenship, was proportionate for safeguarding national security, but you somehow do that unconnected to the Equality Act. And we say that's wrong. The issue isn't the meaning of doing and anything. They are indeed very broad, and here the doing was removing Ms. Begum's citizenship. But what has to be justified is not the doing of the thing in some entirely abstract way, untethered from the Equality Act. It's what you have to justify is doing the thing in breach of a duty or obligation imposed by the Equality Act. What has to be proportionate is doing something in a way that contravenes the Equality Act. Section 192 is a defence. Secretary of State has, on this analysis, breached the Equality Act, discriminated, treated someone less favourably because of a protected characteristic. If they want to, they can use this defence if they can show that that breach of the Equality Act was justified. And
so the word anything should be read as if it said any act mandated or any act required under this act.
no, anything is any act, but what you have to justify is doing that thing in breach of the act. You have to show that's proportional. I'll come on to why we say that is the case. We say for 4 reasons why we say that's the case. 1, we say wrong in principle. 2, it will be incoherent in practice. 3, if you think about how this would work in relation to direct discrimination, which must operate in the same way, it is clear that what you have to justify is doing something in breach of the Equality Act, not doing something in the abstract or doing the thing unrelated. Again, it may help once I explain how it works to try and make good that submission. And 4, SIAC in fact never did a proportionality exercise. No doubt we'll see in a moment because it's not something you can coherently do. But in this case, even if SIAC was right, it in fact never did the thing it said it needed to do. So first as a matter of principle, when you have the way a proportionality defence works, we say, is you have some act that would otherwise be unlawful, interference with privacy, discrimination, whatever it is, and you have to show that doing that otherwise unlawful act is justified by some greater public good. It was necessary for me to discriminate. It was necessary for me to interfere with privacy because that was necessary for national security. And here, the only right that could be possibly being qualified here of any meaningful, the only thing that could have been unlawful, which you have to justify, is a breach of the duties and obligations under the Equality Act. That's what you have to show. Doing your thing in a way which breaches those duties, you have to show that is proportionate. And you can see that, and I'll come back to it, in fact, when we look at how it must work, how it works in direct discrimination context, because that is that's the most straightforward one. So first we say matter of principle, because proportionality is a balance between otherwise unlawful act, justification. I say here the only potentially otherwise unlawful act is removing citizenship in a way that's discriminatory, removing citizenship, breaching section 149.
Sorry, my difficulty with this part of the argument is the starting point. I mean, because deprivation is a power that can only be exercised against dual citizens, rather like deportation can't be exercised against someone whose only citizenship is British. In a sense, every case raises potentially adverse impact, because if you take you're looking at religion, if you're comparing, say, the population of the UK that are members of the Church of England as against the population of the UK who are Muslims, there are more dual citizens, I imagine, pro rata, among the Muslims than among the members of the Church of England.
But can I come? I was going to deal with that because that's the 1491A argument.
Yes.
But can I come back to that? But,
Yes,
but
certainly.
in terms of dealing with section 192, you could very obviously have a discriminatory exercise of power. For example, if the Secretary of State said, "I've got a policy that I'm going to deprive Pakistani dual nationals but not Indian dual nationals."
Yes.
So in principle, you certainly could exercise this. But I'll come back to my Lord's point when I deal with the one. But at the moment, section 192, if we're interpreting it, it is clear that you could have a discriminatory use of the power.
Yes.
And I'll come back to the consequence of that. But secondly, if it's right that you simply look at proportionality untethered from not is it proportionate to have otherwise exercise our power in a way breaching the Act, but entirely separate from the Act, what are you balancing? What is it proportionate to? The impact on Ms. Begum, the impact on her family would have to be the impact on her, but it also have to be the impact on the wider Muslim community. That is one of the harms that we're suggesting here. You have to then balance that against a national security case. If the proportionality is entirely untethered, and we say that's an obviously impossible exercise, and it goes further than that, because we'll see in a moment.
I just don't understand why that's an impossible exercise. Why you don't do what the statute says to you, which is you predicate the purpose of what you're doing is to safeguard national security, and
Yeah.
the test, the only test you need to ask yourself is what I did, which might otherwise be a breach of the Act, proportionate to my purpose of trying to safeguard national security? What's wrong with that?
That's what we say exactly. We say the argument is it's you have to show that doing something that would otherwise breach the Act
Doing anything, but whatever I'm doing.
but it can't be that if what you're balancing on either side of the balance is national security on one side, but on the other side is doing the thing in a way that breaches the Equality Act, not anything at all, because otherwise what you would have to balance is national security against the impact on Muslims, national security against the impact on Ms. Begum's family. What is it proportionate to? That becomes a completely impossible exercise. What we say it has to be proportionate to is you have to justify why you are doing this thing in a way that breaches the Equality Act. And I'll give it may help to turn to my third argument, which is how it works with a direct discrimination claim. Suppose what had happened here is the Secretary of State, say a very straightforward direct discrimination argument. The Secretary of State had a policy of depriving Pakistani dual nationals but not Indian dual nationals, for example. What the Secretary of State could not come along and do is say, you are a threat to national security, this hasn't had a particularly serious impact on you, therefore I've satisfied the Section 192 defence. What the Secretary of State would have to show that doing this act in a way that breaches the Equality Act, treating Indians and people of Indian and Pakistani nationality differently, that is what the Secretary of State would have to justify, not the impact on you, the impact on your family. It would be the thing that would otherwise breach the Act has to be what is justified. So the Secretary of State has to show, well, yes, I needed to treat people from Pakistani and Muslim communities differently, or it was proportionate to do so for this national security reason. It's the obligation imposed by the Act not to discriminate that the Secretary of State has to justify. And we say it's exactly...
I just am in bit trouble about where you get all that from, and maybe I'm just missing it, but the statutory purpose of Section 192 would seem to be where something's been done for the purposes of national security, the Act, as long as it's not wildly irrational, I suppose, that you are not entitled, there's no argument that thereby contravenes the Equality Act. I mean, it would seem to be Parliament saying where national security is in play.
But it would expect that if it could simply say that, and if you do for reasons of national security is not covered. But the reason you get the proportionality, can I show maybe why we do say how it would work in a direct discrimination case? If you have one of the new authorities we produced, tab 72, is the A in the Secretary of State. This is the Belmarsh. You may recall this is the post 9/11 Belmarsh case.
Which bundle are we in?
It should be tab 72, so I don't know where you've got that. It's one of the new authorities. Whole new file. And the reason that was held to be unlawful, you may recall this was foreign nationals who were a danger to national security suspected could be detained, but not British nationals. And that was unlawful. And in this context, unlike ordinarily, you can't justify direct discrimination under the Equality Act, you can justify it under Article 14. Paragraph 68 in Lord Bingham's judgment, Lord Bingham's speech, this is between the D and E. Any discriminatory measure inevitably affects a smaller rather than larger group, but cannot be justified on the ground that more people will be adversely affected if the measure will generally apply. And it's this: what has to be justified is not the measure in issue, but the difference in treatment between one person or group and another. And we're saying that, and here you can't justify treating differently British nationals versus non-British nationals. And if you now apply, imagine that was now under Section 192. Suppose this was a Section 192 case and someone came along and says, well, look, I'm being detained, I'm a foreign national, I'm being detained, but British nationals aren't. You don't say, well, is that generally a proportionate sort of decision, we respectively say. What you would say, and nor do you say, take the Equality Act out of the equation and say, is it proportionate to say, well, you're a threat to national security, it's not a particularly big impact on your family. That is clearly not the way it would work. What you would have to justify is the discrimination. Why are you treating British nationals differently?
So the answer to my lady's question is that you rely heavily on the proportionality lever, which has to be given meaning, and in order for it to have meaning effectively,
exactly.
It's the
That's the only thing, precisely.
Is there anything or any significance to be attached to the word only?
I haven't thought about it, but let me...
It's an open question.
don't know that there is. I'll think about it, but I can't think that there is. But yes, but that's
But
essentially.
you say what it doesn't say is a person does not contravene this act only by doing something for the purpose of safeguarding national security. It says doing for the purpose of safeguarding anything that's proportionate to do for that purpose.
And we say, well, it must be proportionate. If you then have to say, what's it proportionate to? We say, take the direct discrimination. You have to justify what has to be proportionate is treating nationals and non-nationals differently. You have to show that is necessary for protecting national security, not you're a dangerous person and this doesn't have a particularly big impact on your family. It's not proportionate in that abstract sense. It's something otherwise breaching the Act. And in our case, it's taking this decision, I'll come on to the merits of it, but taking the decision without having due regard. And what the Secretary of State would have to do is to say, there could be cases where he says, well, look, I had to take the decision so quickly, I was aware there was equality issues, but I did not have time to consider them for good national security reasons. You then satisfy the defence. But that is what you'd have to show is the thing that would otherwise breach the Act, you're doing that for some national security reason. Here, we say there's no suggestion the Secretary of State couldn't, for national security reasons, have considered the things that he was required to consider. And we do respect to say it's not that surprising an outcome. There are other mandatory relevant considerations. Again, subject to simplex, the Secretary of State is required to consider those. And my fourth point is that, in fact, SIAC never actually does a proportionality
Well, your
exercise.
forensic point is to say that omission, as you would put it, it can feed back into the analysis, because had they tried to do a proportionality exercise, they may have had to ask themselves the question that you say they should have done in the first place.
If they, well, yeah, and there's also that SIAC, in fact, SIAC says at 389, end of 389, they say, well, we say the decision to deprive was proportionate.
It did consider it.
For the reasons it has given elsewhere, the Commission is so satisfied. But in fact, the Commission never decides whether it's proportionate or not, because it doesn't decide it under Article 8, see paragraphs 403 to 405. It's not a proportionality exercise under Article 8. And it's not a proportionality, it's a arbitrariness, 403 to 405. And it's not, SIAC says, a decision it takes at common law, doesn't consider proportionality at common law, SIAC 69. So in fact, even if a SIAC was right, and you do some general proportionality exercise, it's never done that in any event.
So what was the last submission? No proportionality at common law, see paragraph.
69 of SIAC. It doesn't do a proportionality exercise at common law, SIAC says.
Can I go back? I'm still a bit foxed, I'm sorry, I'm really pressed for time, because I have another run at
Yeah,
what
please.
I think you're saying section 192 provides. I'm just looking at the statute. Is this what you read in? That a person doesn't contravene this act only by doing, for the purpose of safeguarding national security, anything that gives rise to discrimination, which discrimination it is proportionate to cause for that purpose, namely national security.
Yes, it wouldn't be, or anything unlawful under the Act.
That gives rise to discrimination, which is, you say, that's the unlawfulness under the act.
Yeah, or in our case, not considering. But
Right.
yes,
Okay.
yes, it has to be the thing under the Act. And you can see from direct discrimination, it is clear that is the case. It's not the harm for you of detaining you. It's not okay to.
You say that's good, but am I right to think that the Belmarsh case wasn't a section 192 case?
Correct. It is not a section 1, but we say it must apply in this. No, correct. It's a.
You read Belmarsh across
Yes.
into section 192. Have we got any section 192 cases?
I don't think there's ever been one. So, but I mean, what I can show, my lady, actually, to, again, perhaps to make this good, is the explanatory notes, which gives. I'll try and do this very quickly. But if the explanatory notes you have at tab 67. And page 2234 gives an example of how this might operate. That's the closest we've got, I'm afraid, to any authority.
Sorry, I've just lost. I was just making notes of myself. Just give me that page ref again.
2234.
2234 of what?
Authorities bundle, tab 67. And you've got an example there of how the draft of the explanatory notes thought this would work. example, denying people of a particular nationality access to sensitive information is not unlawful race discrimination under the Act if it's proportionate in order to guard against terrorist attacks. And if we say how would section 192 work there, we say it is clear that what you would have to justify is treating differently people from that particular nationality. What has to be justified is why are you treating someone from X country? That's the potentially discriminatory act. It's not saying, well, would this upset them? What's the impact on their... You have to say, why am I treating... And I do take that, I accept that's from the Belmarsh case. We say it must be the same. You have to say, what the employer would have to do is saying, why am I treating person from nation X differently from nation Y? Here's a good national security reason. So it's the act that's otherwise a breach of the discriminate, it's doing the thing, refusing to allow you access in a way that breaches the act. You have to say, well, no, it was proportionate for me to discriminate. So that's section 192. And say if you do then apply what we say is the correct test, so SIAC didn't apply its own test, we respectfully say, but the correct test, clearly not disproportionate. I'll now try and whip through, if I can, turn to the section 149(1)(a). This was the one that my Lord Justice Bean asked me about. So this is the argument: is there a requirement to consider? So this is not, and this is the key point. It's not a substantive discrimination argument. Is there a requirement to consider? Am I using this power disproportionately in relation to people of a particular religion, here Muslims, and to then ask oneself, well, if so, is that the result of unlawful discrimination? Or might it be? And the evidence that we have is that this power is used almost exclusively in relation to British Muslims. It's Gareth Peirce's fourth witness statement deals with this, so I won't ask you to turn it up given the time, but 29, 30, 32, all parliamentary group on traffic Britons in Syria, supplementary bundle, page 386. The evidence they have, the Institute of Race Relations, used almost exclusively against Muslims.
Gareth Peirce, fourth witness statement.
Page 521.
So supplementary bundle.
Yeah, sorry, supplementary on 521, 29, 30, 32.
Paragraphs 29.
30, 32.
30, 32.
All
right.
parliamentary group, supplementary bundle 386, used almost exclusively. It's been used about 200 something times since 2002 when it began to be used much more. It was almost never used before that. Used over 200 times, almost exclusively against British Muslims is the evidence. And what SIAC said about this, and I'll then pick up what my Lord Justice Bean asked me, is at paragraph 396. Not attracted to my argument, directs at 1491 and says this is because Islamic fundamentalist terrorism is and remains a potent threat, and it's hardly surprising the Section 40 powers have been used in that context against Muslims, etc. Now, the error we say there is twofold. One, perhaps a minor one. It's not just that it's used against Muslims. The evidence suggests used almost exclusively. But the second error we say is this would be an argument that arises on a substantive discrimination claim. If you came along, you'd say, well, here are the stats, but here it's obvious, or here is a reason it's justified. The only way in which SIAC could conclude on a PSED analysis that there was nothing here to consider, there's simply no equality issue arises, is that the only possible explanation for Muslims being almost exclusively those deprived is Islamic fundamentalist terrorism is and remains a potent threat. And the answer to that is there simply wasn't evidence before SIAC, and that is almost certainly wrong, that the reason that those who are deprived are almost exclusively Muslim is because of the Islamic threat. And the reason we say that is, first, the power isn't only used in relation to terrorism. What Mr. Larkin said in his witness statement is, for the court's reference, paragraph 16, supplementary bundle 804, used terrorism, espionage, serious organised crime, war crimes or unacceptable behaviours. And we know the power was used. This is Mrs. Pearce's witness statement, paragraph 31, page supplementary bundle 522. It was used against Muslims, four Pakistani British men suspected of sexual offences against minors in Rochdale were stripped of their British citizenship in what Ms. Pearce says another context is highly racially, religiously charged. And so if one asks, are those who commit sexual offences or organised crime almost exclusively Muslim? Answer, clearly not. It's also not the case. And again, this is all the things that will be considered on a substantive discrimination claim, not the case that those who threaten national security are almost exclusively Muslim.
No, but surely you have to qualify all those groups with and who are dual citizens.
I was coming on to
because otherwise, I'm sure that there are lots of people the Home Office would dearly love to have out of the country, but because they are only British citizens, there's no power to do so.
But so my Lord has preempted my third point, which is so national security. Again, it's all obvious stuff. There's Irish dissident Republicans, far right activists. Third question is: are those? It's also clearly not the case that those of dual nationality are almost exclusively Muslim. So we know there are something like the evidence. Gareth Pearce, paragraph 21, 6.71 million individuals of Irish descent in the UK. No doubt there are lots of other people with Australian dual nationality, Italian, who knows? And this is why we say, what would one do if one was considering undertaking the public sector equality duty in this regard? You'd start by saying almost exclusively Muslim. That does seem to what the evidence suggests. And then you say why? And you'd say, well, is it right? This is my Lord Justice Bean's point. Is it right that those who are dual nationals involved in serious sexual offending or threats to national security are people who fit within that category almost exclusively Muslim? And the short answer is we have simply no idea. That's what the public sector equality duty is there for. It may be the answer is, once someone did this exercise, they would say, you know what, the people within this category are almost exclusively Muslim, or they may have found something else. They may have found, hold on a moment, when there's a serious paedophile who's convicted and their name is Peter Jones, does anyone check whether their ancestry is Australian, Italian or not? The answer is maybe that's always done, or it might be it's only done in certain categories of case. And that's what you would look at if you undertake. And so that's why we say this conclusion that's reached here is precisely the exercise someone who undertakes the public sector equality duty would do, because it's by no means obvious that the people who fall within that category are almost exclusive, as opposed to being something in the system that's operating in a discriminatory way. Is it the case if a far right person is convicted, someone says, hold on a moment, I wonder where their parents were born? I don't know, maybe they always do, but maybe they don't. And that is the kinds of questions you will be undertaking if you so that's why we say that's the error on the 1491A. It's that it isn't a substantive discrimination claim. It's, was there some questions that needed to be asked here? And the answer we say, obviously yes. Second one is the 1491C. This is the impact on wider Muslim community. And to some extent, there's limits to what I can say because the conclusion was, in a sense, entirely enclosed in relation to this. So it's something I'll have to leave to the special advocates to make submissions on. The only thing I can do, if I may, is just to highlight the paragraphs of Gareth Pearce's fourth witness statement that one would want the court almost to take into closed with them, because the question, what SIAC accepted, is there's nothing in open dealing with how right-thinking people in this country's Muslim community feel they're being treated as second-class citizens and or their welcome is somehow contingent, but said there was evidence that was considered enclosed. And it's important to see what it was that we say needed to be considered enclosed. So what would have needed to be shown? So it's in, I'll just give the court the references. Gareth Pearce's fourth witness statement, paragraph 61, supplementary bundle 538 sets out the immediate reaction to Ms Begum's citizenship stripping, quotes Sadiq Khan, Muslim Council of Britain, Gary Young, journalist, and a whole range of other people, how this made them feel. This is the day or two after as Muslims. You then have paragraph 64, I'm afraid it's paragraph 64, the reaction from other people, and particularly what was at the time that we prepared the witness statement, still on national newspapers' websites. And you'll see the vitriolic and racist reaction linked precisely to the set of anxieties about you don't really belong here. You're not, certain people are not really British, paragraph 64. And paragraphs 9 to 12 of the statement, Gareth Pearce explains why none of this ought to have been a surprise about a high-profile decision of this case. And she refers to various people who've made warnings about it. Paragraph 41B, Professor Matthew Gibney, Professor in Oxford, Nicholas Blake, 42E, David Anderson, 43B, and various others. And she also refers to what happened in the only other cases where you have people publicly, as in this case, deprived of their citizenship, which was Abu Hamza, which she deals with at 53 and 54, and 55 to 57, the Rochdale sex offenders. And all of that, she says, had again the same reaction, questioning anyone of Muslim descent, particularly ethnic origins, questioning their Britishness is the reaction. And the question is, was that considered enclosed? That'll be a question for the court to look at. I can just make three brief submissions. One is, it is impossible to see why, if that was considered, the entirety of the evidence would be enclosed. These are public statements we were looking at from Mayor of London, Muslim Council of Britain, David Anderson, going back many years. If those sort of issues were considered, it's impossible to see why that would be entirely enclosed. Second is what would not be dealing with this point. It's not about what was happening in local communities. We do know this from Open, the Secretary of State considered what was happening, I think in Ms Begum's local community, was there right-wing chatter, I think was one of the phrases used. Was there an Islamist reaction? That is, again, that is not what this ground is concerned with. And the third point is that from what we were told in Open, this is the submissions to the Home Secretary, page 743, supplemental bundle of 3L. The only thing we were told in Open that the Secretary of State was told about wider public sentiment was public sentiment is overwhelmingly negative towards the appellant, general feeling being that she made her decision in travelling to Syria and now must live with it. So certainly from the Open case, it appears he is being told, as far as he's told anything about the general public impact, it's reasons to deprive. Or certainly it's, that's not simply reasons to deprive, but certainly that is the public impact. The public view is she deserves it, no suggestion of these, the potential harmful consequences. So that is public sector equality duty. De facto statelessness. Now, our argument before SIAC was that it's a mandatory relevant consideration whether, if Ms Begum was deprived of her British citizenship, she would not have, in practice, another state that would recognise her as a citizen. The way we define de facto statelessness in our skeleton below, supplementary bundle 147, page 137, is a person is de facto stateless when, whatever their de jure citizenship, there is in practice no state which will accord them admission, meaningful protection, or other rights of citizenship. I think we have the same definition on our grounds of appeal and in our appeal skeleton before this court, paragraph 42. And we get that definition effectively from Lord Carnworth in Pham in the Supreme Court. Again, for the court's note, volume 2, tab 31, page 857, paragraph 21, Lord Commonwealth distinguishes, pick up what Lord Justice Jackson had said, between de jure and de facto statelessness, that is, between those who have no nationality under the laws of any state, that's de jure, and those who have such nationality but are denied the protection which should go with it.
Can you just give the paragraph reference to
21. Now, what SIAC said about this, page 152, end of paragraph 301, she was not de jure stateless, but she could not travel to Bangladesh, a country with which she had no connection and where she could run a real risk of being tortured. Then over the page, putting the submission in those terms does not invoke the concept of de facto statelessness, which carries with the notion that Bangladesh would fail to afford the full panoply of protections afforded its citizens. Doesn't consider labelling matters, real point, full impact not considered, because one way or another she could not go to Bangladesh. Let's say a person isn't de facto stateless if they don't have the full panoply of protections. They're de facto stateless if they have no protection. They're simply not going to be recognised. But I don't want to enter into a semantic dispute. As a matter of substance, SIAC we accept was probably right. The key issue here is, would there be any state that would admit her as a citizen? It's admission that's the key. And if she loses her British citizen, there is no other state that would be willing to admit her as a citizen. And SIAC says, look, that's the heart of it. And our argument was, someone who is de facto stateless is in very much the same position as someone who's de jure stateless. If the state of your origin is not going to recognise you, not going to admit you as a citizen, you're in very much the same position as someone who's de jure stateless. And our submission was that is a matter that had to be taken into account. It's not an absolute bar. It's not like de jure statelessness, which is an absolute bar under section 44, but it is a mandatory consideration. And the dispute before SIAC between the parties, as we understood it, was entirely about whether in fact that was a mandatory relevant consideration, not whether it was in fact considered. SIAC, as we understood it, found in our favour that it was a mandatory relevant consideration, but it found that it had in fact been considered.
Where do we find the ruling that it was a mandatory?
Well, as I say, this is, I've assumed it because otherwise it wouldn't have gone on.
Right.
To analyse it as it is. I would say the dispute between the parties, you see that from the Scott schedule and our skeletons, was almost entirely about whether it was mandatory. We take it from the last line of 304 that SIAC was with us on that. The point that was being made was this was draconian executive action, this is talking about FAM, and that these concepts have to be weighed in the proportionality balance. It's to have to be weighed, but as we understood it, it accepted our argument but found had been complied with. And the reason it was said it has been complied with, I say our understanding of the case had been the Secretary of State's position wasn't that it had been complied with, simply he had an obligation to consider it. It was then Sir James, making oral submissions, pointed to something called the mistreatment risk statement, which you have at page 745 of the supplementary bundle. And this, it was said, showed that SIAC had considered, sorry, the Secretary of State had considered de facto statelessness, or at least the way in which SIAC was characterising it. No country would admit Ms. Begum as a citizen. But it's important, we'd say, to see what this document is and what it's doing. If the court has it, you'll see the first paragraph of
It's supplemental.
Supplemental 745. So this is, it appears, produced by the Security Service. The Security Service is aware of the Home Secretary's practice, which is that if deprivation of citizenship would expose someone to the risk of Article 2.3 mistreatment, Secretary of State's policy is not to deprive. And so this note provides information to the Home Office to determine that issue. And as you'll see from paragraph 3, what is critical is this is a causation issue. This is, would depriving lead to direct consequence, foreseeable, Article 2.3 mistreatment. That's what that's what it's looking at, paragraph 3. Then the conclusion, paragraph 5, within Syria, treatment likely to be broadly the same for better or worse. It's not going to get worse if you deprive her. Bangladesh, and this is the line that SIAC relied on, not possible to speculate is paragraph 6, what will happen to women in refugee IDP camps. We do not consider repatriation to Bangladesh, and then these words, we say, is a foreseeable outcome of deprivation. As such, the Home Secretary may consider there is no real risk of return, let alone for the purpose of complying with the practice, i.e., the consequence of deprivation will not be her repatriation. But for completeness, we note that some people are mistreated in Bangladesh. That's then fed into the Home Office submission to the Minister. If you go back a couple of pages, 742, 3I, the very bottom of the page, summarises SCU Special Cases Unit at the Home Office, advises the Secretary of State, you don't have to worry about your policy effectively because the assessment is it will not be a direct foreseeable consequence of deprivation, that she will suffer Article 2.3 mistreatment. And SIAC said, well, because that material, the 3I, and what you saw, the mistreatment risk test was before the Secretary of State, he had material before him from which he could infer that Ms Begum would be rendered de facto stateless, as it understood it, no country should admit her, if she lost her British citizenship. And we say there are two errors in that analysis. First, we say the correct question is not, did the Secretary of State have material before him from which he could infer Ms Begum would be rendered de facto stateless? It was, did he consider the risk that she will be rendered de facto stateless as a factor militating against deprivation? And the second error, we say, is to infer that he did have material in front of him, or sorry, is to say that he had material in front of him from which he could infer that she will be rendered de facto stateless. If one applies, we say, the correct anxious scrutiny test. But the first error is this. The question isn't, does he have material in front of him from which he can infer de facto statelessness? Is, did he consider de facto statelessness as a factor militating against, something he was weighing the balance against deprivation? What SIAC held, we say, with respect correctly, is that you have to take the reasons for the Secretary of State's decision as being the ministerial submission and with the evidence and the evidence on which it is based, because the Secretary of State, of course, doesn't provide a witness statement. He doesn't, beyond a one-line explanation, doesn't provide any other explanation. So you read this, effectively you read the ministerial submission as a decision letter with the evidence considered, including the closed evidence, as being the evidence placed before. And that was, just for your note, it's section 1, paragraph 116, core bundle 117. So it was dealing with a different point, but it says reasons, you take the Secretary of State's reasons to be what is set out in effectively the ministerial submission. That gives the back and forward arguments for and against why he's concluded what he does. And if one then asks, reading these documents in effect as a decision letter, do they show the Secretary of State has considered de facto statelessness, as SIAC understood it, as a factor militating against deprivation? The answer is they clearly don't. What he's done, he's considered the repatriation issue, which I'll come back to, as a factor militating in favour of deprivation. He's considered, the only reason he's considered that is because he's got a practice of not depriving if it would lead to Article 2.3 or treatment. He's been told, well, that practice, that issue hasn't been, that matter hasn't been triggered here, no bar on deprivation. So it's a factor militating in favour of deprivation. And we say you can't read a decision that says factor X is a reason for doing Y as being, well, I considered factor X was a reason for not doing Y, but it was that way. Let me perhaps give a hypothetical. I hope this is not too far-fetched and probably errors of law. I don't practice it, but imagine you have a planning case where you have a planning policy that says for industrial development in a rural area, if an industrial development is proposed in a rural area, that is a strong reason militating against granting planning permission. And if you then have a decision maker who allows a factory in a rural area, and suppose the decision maker doesn't say anywhere, well, I've taken this into account as a factor weighing against granting planning permission, but somewhere else in his decision, under a heading that says employment prospects, he says, well, notice this is in the countryside where there aren't a lot of jobs, therefore this is a reason why I should be granting planning permission. You couldn't read that decision and say someone who's taken something into account as a reason for doing something, that he also balanced it as a reason for not doing. That's simply not how one reads a decision. Or take our example, or take something close to here. The Secretary of State does have a policy of not depriving, of considering best interests of the child. If somewhere else in his decision he noted that the claimant had a child, a person had a child, we wouldn't say, well, we can infer from that he's taken into account and balanced it. That simply isn't how one reads a decision letter. And here it's a fortiori, because the only place it appears is something militating in favour of, or not preventing, deprivation. The second error, we say, is even reading this as information from which the Secretary of State could infer, and therefore had taken into account de facto statelessness. We say is wrong if one applies the anxious scrutiny test that is required. It may help just to turn up the authority on it. I think Knight referred you to it, but it may help just to turn it up. Tab 22, page 425, volume 1. This is about what amounts to a fresh claim in the human rights asylum context. And Lord Justice Calmless, as he then was, gave the sole judgment. And he set out the meaning of anxious scrutiny, because it's sometimes, courts of sometimes noticed, it's an odd phrase. One should always be careful about getting.
Oh, we were taken to paragraph 24.
Yes, and so it's 22 to 24, and the key wording is, what does anxious scrutiny mean?
Yes.
And it's this, it's middle of the paragraph, in the very special human context in which such cases are brought, the need for decisions to show by their reasoning that every factor that might tell in favour of an applicant has been properly taken into account. That's what it means by anxious scrutiny. Of course, it's both the court and the Secretary of State, and says the Secretary of State has to anxiously scrutinise, then the court has to be sure, show by reasons that every factor that might tell in favour has been taken into account. And if you then go back to the ministerial risk statement, we say if you apply an anxious scrutiny test, and I would say, sorry, I would just add one point, the anxious scrutiny test is particularly important given the difficulties I've already showed you of interfering with a decision after it's been taken. If the Secretary of State has considered a matter, how he weighs it is virtually impossible to challenge on rationality. So it becomes absolutely critical that SIAC is sure that every mandatory consideration has been taken into account. It's the anxious scrutiny, but I say it's even more important given the difficulty of displacing on appeal. And again, if one goes back to the ministerial risk statement, and read it, we say, with the correct anxious scrutiny, we say that is certainly not the Secretary of State showing by his reasons that he has taken into account de facto statelessness. What he's being told is that deprivation, or that it will not be a reasonable and foreseeable and direct consequence of deprivation that she will be repatriated to Bangladesh. And therefore, there's no real risk she'll be repatriated if we take away her British citizenship. But as far as I'm aware, at the time, no country was repatriating its citizens. That simply doesn't tell you anything at all. If any country, if Ms. Begum had been a citizen of any country, you would say the same thing. It won't be, certainly in 2019, a foreseeable consequence of deprivation that she'll be repatriated. It won't make a difference. No one was being repatriated at that time. And in fact, the court may note, as an authority that the Secretary of State has asked to be added, there are still British citizens who have not been repatriated 3-4 years later. So whether or not one is a British citizen, whether one loses one's British citizenship is not going to affect whether she is repatriated or not. And that's all that the Secretary of State is being told in this context. 2019, he's told it's not going to make a difference. It's not going to lead to her being repatriated to Bangladesh. We say, well, no, but that's entirely different. And in fact, one can imagine, flip it round. Suppose this was being a decision taken in Bangladesh. Suppose they had the same policy and they were asked themselves, well, should we strip her of her British citizenship? Would it be a foreseeable consequence of us, sorry, if they were saying, should we strip her of her Bangladeshi citizenship? Would it be a foreseeable direct consequence that she will be repatriated to Britain? Had it done the analysis properly, the answer would be no. She wouldn't be repatriated to Britain if we take away her Bangladeshi citizenship. As I say, there are still that hasn't been the consequence for a number of women, certainly not at that time. And so it doesn't tell you anything about whether the person's de facto stateless. That wouldn't mean Britain won't recognise her as a citizen, won't admit her if she came. So that's why we say that is all this statement is telling the Secretary of State. And if you read that without the anxious scrutiny test, has it been shown by its reasoning that everything was taken into account? We say it doesn't come close to that. And we do say, and again, we do say this matters. It matters because of the difficulties that an appellant has challenging anything in SIAC once the Secretary of State has directed their mind something. It then becomes critical. What SIAC can't at that stage interfere effectively, but what they can do, SIAC, is make sure with the anxious scrutiny lens that things really have been considered that require consideration. And we do say, because otherwise the decision really does become entirely unchallengeable. Because it's at that stage, it's the Secretary of State stage who needs to do the balancing exercise. And so our submission is, say, two reasons. One, didn't ask the right question, which was, did this citizen show this was considered as a factor militating against deprivation? It was then balanced. We say no. And two, even reading this decision, even reading this document as telling you anything about de facto status, generally we say is wrong. It's just saying, I'll tell you what the consequences will be of losing your British citizenship, which won't be repatriation to Bangladesh. I think 5 minutes in.
Well done, Mr. Squires and Miss Knights and the whole of your team for marshalling all the arguments together so clearly and ably on time. So I think that concludes today's hearing. We resume tomorrow. Yes, Mr. McCulloch.
My lady, I'm sorry to rise at an unwelcome time of the day. It's merely a logistical question. I think according to the agreed timetable, we're due to have all day tomorrow in open and then go into close on Thursday. If there's any risk of us going into close tomorrow, then certain steps will need to be taken logistically.
No,
but if the court
provided
indicates
you're all comfortable that a day is enough closed.
it'll be ample.
Yes, then we will not. You're not in jeopardy tomorrow.
I'm very grateful.
Thank you. 10:30 tomorrow. Thank you all very much indeed.
Able